Good morning, everyone, and thank you for joining us. My name is Jason Cogdell, and I'm one of two benefits attorneys at ProBenefits, and I'm here today with my colleague Laura Bibb, and we're pleased to join you to cover this topic for our June client webinar series, which is an update and refresher on COBRA compliance and specifically what employers and advisors need to know about COBRA. Hope that you find this session practically helpful today. As always, this session is recorded. We'll provide you a copy of the slides, and you're welcome to share those with any of your team members that may benefit from it. Hope you can hear clearly. If at any point you can't hear clearly, you may want to switch back from the phone to the speakers or vice versa. We are at the whim of the internet connection, so that is a factor. Your questions are welcome through the question box, and Laura and I will be monitoring those as we go. And if we don't get to your questions through the question box or answer them audibly live during the session, we'll get to them at the end. And you're always welcome to contact us at compliance@probenefits.com. So without further ado, I do want to formally introduce Laura. Some of you heard me introduce her during our last client webinar that I led. This is the first one that Laura has been on. Laura has been with us since April. Laura is a tremendous attorney that we're very blessed to have on our team. I've known Laura for over 10 years. Laura has served in several capacities. She's worked at a large regional insurance brokerage. She's also been in private practice, most recently with a national benefits firm, and she's very good at what she does, and we're thankful and blessed to have her as part of the ProBenefits team, and you'll hear from Laura in just a few minutes. Before I shift into COBRA, I want to share a very brief reminder and confirmation about two deadlines that apply for July 31st. The first is the PCOR fee, the Patient-Centered Outcome Research Institute fee, that is an ACA fee, quite frankly, is a nuisance fee that has applied since 2012 and will apply for just a short time longer through the 2019 calendar year, with fees paid in 2020, at which point it expires. But PCOR fees must be paid annually for any self-funded group health plan, and that includes HRA. So for HRA plans that we administer or have administered, we prepare the IRS Form 720 and help the employer pay the fee, which is a minor fee. It's just a nuisance fee, $2.26 or $2.39 per employee for the entire year that was enrolled in the plan. But it is something that needs to be done. So we've been sending out emails and assisting our clients with PCOR fees. If you as an employer have a self-funded health plan that the carrier or the TPA is not filing on your behalf, that is something you'll want to take a look at before July 31st to confirm this round of PCOR fee submission only applies to self-funded medical plans or HRAs that ended in the calendar year 2017. Only those that ended in the calendar year 2017 are due by this July 31st. And then any plan that's ending in 2018 will be due next July 31st. But just want to say a quick reminder about that. Let us know if you have any questions or want to discuss that in more detail. And then finally, no surprise, the calendar year Form 5500 filing for plans that ended December 31st, 2017 are due 7 months after the plan year, so July 31st. That's something that we're very involved with as a Form 5500 preparer, getting those forms done now and making sure that they're submitted by July 31st. Just a quick refresher, Form 5500s are only required for health and welfare plans that had 100 or more employee participants enrolled on the first day of the plan year, in this case, January 1st, 2017. The only other way a health and welfare plan would have to file if it's under 100 would be if it's funded by a formal trust. So the 100 threshold applies to most all plans. Our last client webinar was on 5500s in detail, and that is available, slides and recording, if that would be helpful to anyone who's not sure about their Form 5500 obligations. Now, shifting into COBRA, what Laura and I are going to cover is a refresher on COBRA requirements, starting with the basics of what employers and advisors need to know. We're going to cover, what the timeline looks like, what the required notices are, and those types of issues, what benefits are subject to COBRA or not subject to COBRA. I'm going to talk about some common compliance issues, and then we'll also answer your questions and some common questions that are posed to us. Now, what's the context? Why discuss COBRA, which is a federal law that's been around for seemingly ever, and frankly hasn't changed, and other than some very minor changes to COBRA over the past 10 or 12 years, and nothing significant in the ACA time period. What is significant about COBRA? Well, the main significance of COBRA is not what has changed with COBRA, but what has changed all around COBRA. And because we live in the compliance era, and we can all agree that the Affordable Care Act and other items of federal law, including HIPAA and ERISA, have raised the bar and the standard from compliance and the focus on compliance at the federal level and the enforcement level, COBRA is more closely scrutinized. Not only that, but just practically, employers in America, generally speaking, have larger turnover than at times in the past. Health insurance is more expensive and more important to many individuals who lose employment or who lose full-time status or whose spouse loses employment or full-time status. So for all of these reasons and many others, the focus on COBRA has been as significant over the past couple of years than ever before in the history of COBRA. Anytime the Department of Labor audits a group health plan, which is typically not random, no matter what people out in the marketplace may say, typically any group health plan audit is triggered by something. It might be a COBRA complaint. It might be an ACA violation or failure to file a 5500 or ACA reporting. It might be triggered by something. But when the Department of Labor does a group health plan audit for one or more years, part of that audit focuses on COBRA. Who has been subject to COBRA? What notices have been provided? And audits are more, not necessarily more common, but they're more comprehensive and lengthy and time-consuming and expensive in the ACA era. There have also been some Florida class actions, some litigation that arose in Florida with those pesky plaintiffs' attorneys in South Florida, and as they often do, starting trends. And these class actions have focused on COBRA compliance of large employers and associations. And that focus on COBRA in Florida, even though that hasn't necessarily trickled to other jurisdictions and states, even in the Southeast or around the country, that has raised the attention level and the awareness of employers and organizations and compliance firms that COBRA needs to be done, and it needs to be done right. We no longer live in a scenario where the employer can just mention COBRA in a termination letter, not even give a formal election notice, and then just deal with what may come. That's a thing of the past. COBRA administration is more valuable than it ever has been before, and today is not designed in any way to be a sales presentation for ProBenefits COBRA, but I will say that we do COBRA and we do it well. We have an entire team of people that do COBRA for approximately 700 employers of all different sizes in many different states. But the reason that our COBRA has been popular, the reason that COBRA administration for other firms other than ProBenefits has been popular, is that the days of the employer doing it internally, the days of self-administration of COBRA are long gone. And any employer that's doing it is in a position that they need to revisit that and to consider what the risks are. Not only what are the required notices, but what happens when something goes awry. How are you handling COBRA appeals? Are you handling all these issues that we're going to talk about today regarding the duration of COBRA? Is it an 18-month scenario? Is it a disability extension? Is it a 36-month scenario? COBRA, frankly, is complicated, and it takes time. And you have to have people that know what they're doing and know what all the issues are, what are the exceptions, how to handle the timelines and appeals and all that. Otherwise, practically, as listed on the last bullet point on this slide, one significant value of outsourcing, even though it's not built into the fees, is that outsourcing provides a buffer between former employees and the employer, a communication about coverage and termination and payment, and that's very valuable. At ProBenefits, we have to deal with, for our COBRA clients, payment issues, who hasn't paid or who didn't pay the right amount or who didn't pay on time. And something that Laura and I handle are non-standard COBRA scenarios. Our team does a great job on a daily basis, but we have things come up all the time that are non-standard, or appeals or second appeals filed by COBRA qualified beneficiaries that we have to deal with the appeal and make sure we're protecting the employer, but that the employer is following all the rules that COBRA and ERISA require. So the moral of the story here, COBRA administration is important. It's not expensive for those that are wondering, but it is important and it's vital to protect the company and its interests in terms of this very valuable federal legal requirement. Laura, how about sharing with us an overview of COBRA and a refresher on the basics?
Thanks, Jason. And I've met several of you who are on the call and worked with you, and I do look forward to working with the rest of you. I've enjoyed my time here so far, and look forward to getting to know you all better. COBRA overview, as you see here, COBRA can be broken down pretty simply as a qualified beneficiary. So this is someone who's enrolled in coverage, who loses group health plan coverage due to a qualifying event. So they've experienced one of the 7 statutory events outlined by COBRA. Most often, this is a termination of employment or reduction of hours. We also have a dependent who might age out for coverage, or divorce or legal separation, but those are the most common. So they've lost group health plan coverage due to one of those 7 events. That individual may elect to continue coverage for a limited time, and we're going to talk about what that time looks like, but generally it's 18 or 36 months, depending on which qualifying event they experienced. And then they continue that coverage by paying for it. So there is a premium associated with COBRA coverage, and that qualified beneficiary is going to be paying that premium and have to continue to pay that premium for the duration of their COBRA coverage in order to maintain their coverage in place. And one of the things that comes up quite frequently is that not everyone is eligible for coverage. So there has to be a triggering event and a loss of coverage. You have to have both of those things. We often see the situation where there might be a triggering event. We might have a divorce or another one of the events that happens, but it doesn't actually result in a loss of coverage. So in that instance, we wouldn't have someone who's eligible for coverage. But this is COBRA broken down most simply, and just remember there has to be a triggering event and a loss of coverage. So to whom does COBRA apply? We're going to talk about to the employers to which it applies and the individuals. COBRA applies for employer purposes, is going to apply to all employers with 20 or more employees, and that's total employees, full and part-time, measured on a typical day during the preceding calendar year. So generally, the way we see employers handling this is once they reach that 20 employee count, they start administering COBRA on the next plan year basis. That's how most employers handle it, unless they have a situation where they've hit 20, and maybe perhaps because of some layoffs or different changes, they might fall back below 20. They may not be subject to COBRA, but that's typically what we see. There are some exceptions for governmental plans and church plans, and you see the asterisk here for governmental plans. While governmental plans aren't subject to COBRA directly, they are subject to the Public Health Service Act, PHSA. And while not being subject to COBRA, the PHSA does have continuation rules that are very similar or same to COBRA. So these governmental plans are actually, in essence, subject to these continuation rules as well, just by virtue of a different law. On church plans, I'm not going to get into great detail on that, but I do want to point it out that church plans aren't subject to COBRA. I will say that that is a difficult determination to make, what constitutes a church plan. There are various wrinkles in those rules, and so I would just caution you if you're working with church plan employers, or if you are a church plan, just to make sure that you have thoroughly analyzed that issue and make sure you actually do fall under that exception, especially given the penalties that apply under COBRA. And even employers who aren't subject to COBRA may be subject to other state continuation laws that may require them to provide continuation coverage under that state law. So just so you're even though you may not be subject to COBRA, you may not be out of the woods as far as providing continuation coverage of some sort. Individuals who are subject to COBRA are all qualified beneficiaries who have been covered under the group plan must be offered coverage, COBRA coverage. This includes employees, spouses, dependents. The key here is that the individual must have been covered under the group health plan prior to the qualifying event. And next, we're going to talk about the plans that are subject to COBRA. And Jason, if you could advance the slide. COBRA applies to all group health plans sponsored by employers. The definition of a group health plan subject to COBRA is one that provides health care and is maintained by an employer. So it's pretty broad, and most of us know that health plans, health insurance plans, whether fully insured or self-funded, are subject to, the state continuation slide we've got here. This is just an overview of state continuation laws. So if you are working with groups that aren't subject to COBRA, this provides an overview of state continuation. Moving now to plans that are subject to COBRA. As I mentioned, these are group health plans that provide health care and maintained by an employer. So the first couple of plans listed on this slide, I think we're all very familiar with being subject to COBRA. We've got health insurance, dental insurance, vision insurance. But the remaining plans on here are often plans where we see mistakes by employers of failing to offer COBRA, failing to realize that these plans are actually subject to COBRA. So we've got group cancer and critical illness plans other than fixed indemnity benefits, prescription drug plans. So if you have a standalone prescription drug plan, that is also subject to COBRA. Health FSAs. There is a limited COBRA rule for health FSAs where a participant has underspent their account, but health FSAs are subject to COBRA. And then HRAs. Here's an area where I've seen several mistakes by employers with regard to EAPs, wellness programs, and on-site clinics, and also telemedicine arrangements, which are gaining popularity among employers. These benefits are often not offered under COBRA, even though they provide health care and are maintained by an employer. So on-site clinics, there are certain rules with regard to whether the clinic actually provides health care or not. But like I said, these are benefits where we frequently see employers fail to offer COBRA. Another exception for plans subject to COBRA is a voluntary exception. Most employers consider a voluntary plan to be one that the employee pays 100% of the cost of coverage. And a lot of times employees may actually pay 100% of the dental or vision premiums, or even the cancer or critical illness policies. But that's not actually the definition under COBRA for the voluntary plan exception. And even if the employee is paying 100% of the cost of coverage, the plan is still subject to COBRA if it meets the definition of providing health care and maintained by the employer. So we've talked about what plans are subject to COBRA. We're next going to talk about what plans are not subject to COBRA. So there's a large laundry list of plans that are subject, and there's also a list of plans that aren't subject to COBRA. You can see here life and AD&D plans, disability plans, HSA accounts, dependent care FSAs. And the big key to remember here, and as you can see with this list of plans, is these are plans that do not provide health care. Remember the definition of a plan subject to COBRA, one of the components is that it provides health care benefits. So moving on to the COBRA timeline, I think it's helpful whenever you're thinking about COBRA to think through how COBRA comes into play from start to finish. And this is just a brief overview of the COBRA timeline from when group health plan coverage starts to when COBRA may terminate. So the first thing is we've got the group health coverage commencing. You have a participant who enrolls in coverage, and once that participant enrolls in coverage, within 90 days after their coverage begins, you're going to be required to send a COBRA initial notice. The participant will continue on, and at some point during the course of their coverage, they may experience one of those 7 qualifying events. And if that occurs and they experience a loss of coverage, then the next notice along the timeline that we see is the COBRA election notice. This is actually, there are a variety of notices. We're going to talk about all of them in just a little bit, but this is one of the most important notices because the employer wants to make sure that we get this out. It's informing the participant of their right to elect COBRA. Another important aspect of this notice is that it starts a COBRA election clock for the participant. So the next we'll see in the timeline is the election, but once we get the COBRA election notice out, that 60-day clock starts. And the timeline for the COBRA election notice, we have 44 days after the qualifying event. So after one of the 7 qualifying events, the plan has 30 days to report that occurrence of the qualifying event to the TPA, and then the TPA has 14 days to get the notice out. And typically that happens much more frequently than the 44 days. As I mentioned, we want to make sure that we get that COBRA clock, election clock rolling as soon as possible. So once the COBRA election notice has gone out, the next event on the timeline is the COBRA election deadline, and that's 60 days after the election notice. So once that 60-day period has expired, then the COBRA rights no longer exist, and the participant will not be able to continue as a COBRA participant. But if they do elect COBRA within that 60-day window, the next item on the timeline is the payment of the initial premium. So the initial premium payment is a little different than the other premium payments along the period of coverage because it's due 45 days after the election. So we've got, if the initial premium payment is due, then we've got COBRA that continues for the maximum period of coverage, which could be 18 or 36 months. And at some point, coverage under COBRA will terminate either due to the expiration of these maximum coverage periods or for some other reason. If the participant doesn't continue to pay their premium, or perhaps they pay their premium on an untimely basis, then COBRA can terminate for those reasons as well. Then would be prior to the expiration of those periods. And then finally, at the end of this timeline, we've got a notice of COBRA termination. And we want to get this out as soon as possible to inform the COBRA participant that their coverage has terminated. So that's the timeline. We've talked a lot about the triggering events. I want to just briefly go over the next slide that deals with these triggering events. As I've mentioned before, there are 7 designated events under the COBRA statute that can be deemed qualifying events. If there is a loss of coverage, remember again, there has to be, for COBRA, there has to be a qualifying event plus loss of coverage. So you can see here on this slide, we've got the 7 events laid out for you. Again, most common, probably the termination of employment or reduction of hours, but we also have dependent ceasing to be a dependent under the terms of the plan, divorce or legal separation, and that can be a little tricky depending on the state in which the employee is in, whether that state actually recognizes legal separation or not. North Carolina doesn't have a formal legal separation process, but some other states do. We also have an event of a covered employee becoming entitled to Medicare, death of the employee, and then the last qualifying event is a fairly limited qualifying event for an employer who experiences bankruptcy. This applies only in the context of retiree plans. So this qualifying event doesn't come up that frequently, but it can come up if the employer sponsors a retiree plan and if the employer does go through a bankruptcy. So we talked about, we've already talked about some of the COBRA notices. We've got here an outline of the required notices under the COBRA statute, and then optional notices that aren't required but are recommended. And I really want to highlight here the point that there are more than just the initial and the election notice. These are probably the 2 notices that employers and others talk about most frequently, but you can see here that there are several other notices that are either required or recommended. And we handle all of these notices as part of our COBRA administration for employers or plans. And one of the importance of these notices, not only the required notices and the recommended notices, you can see here that many of these are, even though they're not the election notice, they're communicating to the participant changes in their COBRA coverage or things that are happening. Notice of a premium shortfall by an insignificant amount. So making sure that everyone is on the same page as far as the COBRA coverage is concerned. And if you have additional questions about these required notices, we're not going to get into them in great detail just in the interest of time, but we can certainly address those through the questions or after the presentation if you have any follow-up questions. And next, we've got the duration of COBRA. We talked previously that COBRA is for a limited amount of time, so it does not continue on indefinitely. But we do have rules under COBRA about those maximum length of time for COBRA coverage. And the first is 18 months, and this is if the qualifying event is a termination of employment or a reduction of hours. So this is where the employee has terminated either voluntarily or involuntarily employment, or they've experienced a reduction of hours, then the length of COBRA coverage would be 18 months. There are certain qualifying events where the coverage is beyond this 18 months, where the coverage is a maximum of 36 months. If the triggering event is a dependent ceasing to be a dependent, there's a divorce or legal separation, death of the employee, or the employee becoming entitled to Medicare. And these, you'll notice here, all of these relate to the dependents, so not to the employee themselves, but the maximum length of coverage for the dependent who's a qualified beneficiary under COBRA. There are also is a special rule for multiple qualifying events that impacts the duration of COBRA coverage, and Jason's going to address that in the next slide.
As Laura mentioned, most of the time, by far the majority of COBRA triggering events include an 18-month COBRA duration. There are some exceptions, and one of the number one exception, and the time when the 36-month COBRA period applies, basically the doubling of the 18-month period, is when either there's one of the specified events that Laura mentioned on the prior slide, or there's a situation of multiple qualifying events, which only happens in a limited scenario, where, as indicated by the slide, the first qualifying event is termination of employment or reduction of hours, and then inside the 18-month regular COBRA period, there's a second qualifying event that, for the spouse or other dependent, extends the COBRA period by another 18 months. So the 36 months when this multiple qualifying event, or specifically the second qualifying event, happens, is retroactive to the original triggering event. So COBRA never, under any circumstances, lasts more than 36 months. It's 36 months from the original triggering event, not the second qualifying event. And there are a number of qualifications on the multiple qualifying event rule. I'm not going to go into detail on those or share any specific examples, other than to just make you aware that there are situations where the 36-month rule applies, either from the start or based on a second qualifying event during the 18-month period. And this would be an example, as I said earlier, that COBRA is complicated and that individual situations need to be studied closely and addressed carefully to make sure the plan and employer is doing what it needs to do. Another time that COBRA can be extended, and the only time that COBRA is between 18 and 36 months, is the disability extension. And we don't see this a lot, but it does happen a number of times per year, and that's where an individual is disabled either before the triggering event or within the first 60 days that COBRA applies. And when that happens, the COBRA rules, in order to assist that individual with coverage until Medicare kicks in, extends COBRA by an extra 18 months for 29 months. And again, there are qualifications that apply to the disability extension, but this extension only applies to individuals that are determined by the Social Security Administration to be disabled. They are disabled whether they became disabled before or after the triggering event. They're disabled within the first 60 days of COBRA coverage, and they meet certain notification requirements. Where the disability extension applies, the plan could charge more, up to 50% more, for the coverage during the additional 11 months. That doesn't necessarily happen often, but this is, again, another way that COBRA coverage can be extended. So without belaboring the point there, just want to make you aware of these situations generally so that you can help spot the issues that when it may apply. But again, that's something we assist employers with doing. Not long ago, I spoke at an event, and what I'd been asked to do was to present on common mistakes of employers and some surprising benefits compliance rules. One of the things that I mentioned in that presentation, and I actually asked for a show of hands, and I can't remember if I said true or false, or just how many of you know that when someone is on COBRA for one or more group health plans that when open enrollment comes, that the qualified beneficiary, the COBRA participant, has open enrollment rights to change plans. And then there was a mixed response. Some employers knew that, some advisors knew that, some didn't. Very few people admitted to knowing that not only does that COBRA qualified beneficiary have open enrollment rights for that benefit that they're already enrolled in, they actually have broader open enrollment rights to even elect coverage that they weren't enrolled in, because a COBRA participant going into open enrollment has the same rights as other active employees who are enrolled. Now, we don't see very often that a COBRA qualified beneficiary picks up a vision plan or a dental plan that they didn't already have. That doesn't happen often. Partly it doesn't happen often because the employer never tells the person they could do that. But sometimes those are new benefits, and COBRA qualified beneficiaries can't take a new benefit that wasn't offered when they were employed, but they do have open enrollment rights, the same as active employees, and that means that open enrollment and qualifying events during the plan year. So it is important that COBRA qualified beneficiaries receive open enrollment materials. Now, sometimes this is just as simple as getting the updated rates with a new coupon book, and that's something that we provide COBRA participants for plans that we are working with. But it's important for the employer to know that COBRA participants do have rights, just like active employees. And that's something, particularly because a former employee could file a complaint that could trigger some scrutiny that we want to make sure that we take care of. And I won't belabor the point on that, but it is a key best practice point. Another key point relates to the COBRA Premium. Now, one of the key things that employers know is that when an employee or former employee elects COBRA, that they have to pay for it. Absolutely, they have to pay for it. It's required to be paid for the employee. An employer could subsidize it, but there's no legal requirement that an employer do so. So once the COBRA premium is determined, and that COBRA premium, the maximum COBRA premium is 102% of the cost of the coverage. And generally speaking, the 2% goes to offset administrative expenses, but 102% of the cost of COBRA, cost of the coverage. Once coverage is elected, the COBRA premium must be paid, as Laura says, within 45 days of the election, and that COBRA participant has to pay not only for that month, but back to the date of the triggering event. So most of the time they're paying 2-3 months of coverage. And that starts the payment cycle. Again, I mentioned the coupon book. Payment is due on the first day of the month for which coverage is applicable. For this month, that would mean coverage for June 2018 for any COBRA participant is due on June the 1st, with a 30-day grace period to and including June the 30th. And importantly, that 30 days is a grace period. The deadline, the due date is not June 30th, it's June 1st with a 30-day grace period. And that's required by law. But it's not required by law that if the person pays late, even 1 day late, the employer is not required to receive and accept that payment. The employer could choose to do so, but it's not required. Many COBRA terminations are for failure to pay on time. Some intentional. The qualified beneficiary just decides to let the coverage lapse back to May 31st. The coverage is terminated. But some are unintentional. And as a COBRA administrator, we deal with all the time payment that is made late, either electronically or by hard copy check, where it is delivered late. Now, a hard copy check, if the mailing is dated by June the 30th, it would be accepted. The mailbox rule applies under ERISA. But if dated after June 30th, it would be late. The plan would not have to accept it. And generally speaking, plans allow that coverage to be terminated and not reinstated. And the person may appeal. But generally, those appeals are denied. And the COBRA coverage is terminated back to, in this example, May the 31st. But a best practice point, vocabulary, as you deal with your COBRA participants, hopefully your COBRA administrator is doing that for you. But as you consider it, it's a best practice point that the deadline is the 1st, the grace period is the 30th. If, for example, the employer wanted to help an employee and extend when payment would be accepted, if hypothetically the employer or the administrator wrote to the COBRA participant and said, in order to assist you, we have extended the due date to July 15. Well, know it or not, that plan has extended the due date to July 15th, and then with another 30-day grace period, because there's always a 30-day grace period on top of whatever the due date is. So what that employer wanted to do was extend the grace period, not the due date. And this is something we've trained our team on, and we just have to get good with the vocabulary and the vernacular in order to make sure that we're doing what we're supposed to do, but not providing rights beyond what the employer is required to do or wants to do. Building on that point, the COBRA premium is technically determined once every 12 months. There's a formal 12-month determination rule that says that once the COBRA premium is determined by the employer, this is usually on the group health plan year, but it's not always. Once the premium is determined, it needs to be locked in for 12 months. And these COBRA rules are a little bit antiquated in the fact that they don't really account for short plan years. They don't really account for early renewals or late renewals or some of the situations we see in the modern marketplace. But as a COBRA administrator, we always advise our employers, once you set the COBRA rates, let's keep them for at least 12 months, and then you can change them. And so, certainly let's set a conservative COBRA rate, charge 102% of the cost of coverage based on what we know right now, but let's lock that in. And that's part of what the employer needs to do to make sure that it's following the rules regarding the COBRA premium. Now, some other common issues and mistakes, Laura and I mentioned some of them separately, and in the interest of time, I won't belabor the point on these. One of the issues we see as a COBRA administrator is, in order for us to send out the notices and administer COBRA, we have to know about the triggering event. So the reporting from the employer to us as a COBRA administrator is key. The same way us acting on that information and getting the notices out timely is key. And one of the things, just to be frank, that causes problems is sometimes when terminations or losses of coverage are reported late, and it creates a problem of the election notice being sent out too late. So one of the things we do to alleviate that problem is send the election notices out immediately. Technically, the employer has 44 days to get it out, as Laura said, after the triggering event. But in case the employer is waiting a little bit long, we're going to get those out right away. The other thing is that we're looking at new ways in which to communicate with the employer to receive information about triggering events more quickly. And we'll have more information on that in coming days. Carrier notifications from the employer or the broker to the carrier about whom to terminate or whom to reinstate, and the timeliness of those communications is a common issue to be dealt with in COBRA administration. The timing of the employee's termination due to inactive status. I could do a whole webinar on the topic of when an employee should be terminated from coverage that's been on a leave of absence, FMLA or non-FMLA, or inactive for any reason for the full FMLA period. But the short answer is that if someone is inactive on a leave of absence or otherwise, whether FMLA or not, if that person doesn't return to work within 12, 13 weeks, the FMLA period or the short-term disability period, that person needs to be terminated and offered COBRA. The COBRA clock needs to start. That employer doesn't need to leave the person on the plan indefinitely, because ultimately what that employer would be doing would be offering COBRA and starting the COBRA clock without even recognizing it. Similar issues relating to the stability period under ACA, I won't get into those. And I won't get into COBRA appeals other than to say this is a big part of what we do, is handling appeals and make sure we're protecting the employer the best we can. We see frequently that not only employers fail to report triggering events, but some events aren't recognized, or the employer may think what the employee did to get terminated constituted gross misconduct, when in fact, gross misconduct is a very high standard. And Laura and I typically advise employers that unless this was the most egregious thing that's ever happened, that COBRA should be offered. And the gross misconduct exception to COBRA, and as a reason to not offer COBRA, is used very sparingly and only in situations that are clear that there was gross conduct, some type of significant embezzlement from the company or otherwise, and not just a routine mishap that caused a termination of employment. Employers need to offer COBRA for all the benefits that Laura mentioned, and we see very frequently employers offering COBRA for some, but not all required benefits. She mentioned FSA, HRA, some of the non-major medical plans like telemedicine, and certainly any plan that's subject to COBRA, like dental or vision, even if it's 100% employee paid, it's subject to COBRA, and COBRA must be offered. It can be charged for, but it must be paid. And there are other issues and mistakes, but those are the key ones and the ones that we see most often and wanted to mention in this context. Now, what happens if a mistake is made? If a mistake is made, it can be corrected. Might there be some risk? Sure. And that happens with any mistake we make in plan administration when the plan documents aren't followed or a particular filing isn't made. But as in other scenarios, mistakes can be corrected. If an employer comes to us and says, we just realized this 1, 2, 3 or group of employees was terminated, or they were merged with another entity and we didn't offer COBRA, let's assess the situation. Should they have been offered COBRA? If so, let's offer it to them now, even if late, if that's practical within the carrier rules. But there are ways to correct or at least minimize risk. And so a big part of what we do when employers do make mistakes and when plans make mistakes or carriers make mistakes, and it happens, and from time to time we even make mistakes too, and we want to correct those, and that is, let's get involved, let's study the situation, let's put our best minds on this, and let's figure out a solution to remove any risk or to minimize the risk the best we can. So that's certainly a big part of what we do and a big part of COBRA, because most of the time employers aren't perfect, carriers aren't perfect, and we're not perfect either. So we want to make sure that if any failures to comply happen, that they are identified and rectified to the best of our ability as soon as possible. Again, in the interest of time, I'm not going to get into the Medicare topic, but again, we will provide you these slides. I know I went through the last part of this quickly, but I wanted to get you wrapped up in time. I want to thank Laura for her time. I want to thank you for your time and joining us today. We've had some good questions submitted, and we've answered a lot of those in writing. But if you have an additional question that you'd like to submit today, Laura and I are going to hang around for another 10 minutes or so, and we'll answer the questions in writing through the question box. If you have something that's a little more involved that you'd like to talk about, feel free to call us or send us an email at compliance@probenefits.com, and either me, Laura, or a member of our COBRA team will be happy to talk to you. You'll get an email likely tomorrow with a copy of the slides and a link to the recording in case this would be helpful to you or a member of your team. And as always, we appreciate the opportunity to work with you and look forward to serving you in whatever capacity. And if you would like to work with us in the area of COBRA administration, we'd certainly love to work with you on this. Again, thanks for your time. We'll hang around for a few minutes to answer some questions in writing, and have a great day.